thank you so much for joining us for this interview. So we have several Sudanese organizations that are conducting documentation for purposes of advocacy. However, what is the difference between conducting this type of documentation for advocacy purposes and documentation for purposes of accountability?
Certainly, there is a difference between advocacy and accountability, and that difference to me is about the ultimate objective. So when we think of advocacy, the way that I'd like to define advocacy is sharing of information with either a general audience or a targeted audience in order to ask them to do something with that information. That can include policy changes, legal reforms. It's about advocating about something that is going on and sharing information. When I think about accountability, I think of it as engaging in a legal process. In this case, because we're discussing international criminal law, it's a criminal process to hold an individual accountable for the commission of a crime. And so based on those two different objectives, there are different ways and also different standards and different protocols that must be followed in order to be able to ultimately achieve those objectives.
Could you tell us what some of the ethical considerations that civil society actors should have in mind when conducting their documentation work?
So there are a number of ethical considerations that civil society organizations need to consider when they want to embark on documentation of international crimes. First and foremost, it's important to know that as civil society, there are certain limitations about what civil society can and should do in an investigation because we are unofficial investigators. And so we have to make sure that when we are documenting, we are doing it in a way that will not potentially undermine or harm a potential future investigation. So as civil society, we have to be very thoughtful and very careful about what we're doing and how we're doing it and what the ultimate goal is so that we can make sure that we can have a successful outcome.
So after conducting the documentation work, this information often has to end up in some type of criminal accountability process. Could you tell us what some of the various accountability processes are? And in this case, I'd like you to focus on universal jurisdiction.
So we've been discussing universal jurisdiction, which is an avenue for accountability that is not quite domestic jurisdiction because in many cases, especially during conflict, there's no access to domestic law and to domestic courts for accountability. And it's not quite international, such as an international institution like the International Criminal Court, which also has its own opportunities, but also its limitations. So universal jurisdiction is looking at a third state, a state that is not necessarily connected to the crimes themselves, but where there may be an opportunity for a criminal proceeding. Now, the legal principle of universal jurisdiction is quite simple. It's the legal authority for a state to prosecute a crime, in this case, and most often it's international crimes, that happen outside of that state's territory. Some states might require a link to the territory, either by virtue of the nationality of the perpetrator or the nationality of the victim, or they might require the presence of the alleged perpetrator on their territory, but it still opens up an avenue for accountability for international crimes in a third state.
There are several universal jurisdiction cases that have been tried in Western countries. However, we haven't seen that much of universal jurisdiction being practiced in other regions. Do you see a potential for the exercise of universal jurisdiction in other regions, such as East Africa, for example?
You know, the closest that an investigation and a prosecution can happen to the location where the crimes occurred, the better. Because ultimately, we're seeking justice, and justice is for the victims, it's for the impacted communities, and it's also important for each state to develop its own capacity and legal culture to address international crimes. But unfortunately, during conflict or when there isn't an independent judiciary, it's hard to bring forward cases such as these and make sure that human rights are also respected during the proceedings in certain contexts. And so I think it's important to think about other opportunities But the closer we are to where these crimes occurred, the better it is for the investigation, for the impacted communities to be able to have access, to be able to understand and even participate in the proceedings. And so I think it's a very interesting idea to explore universal jurisdiction, not in Europe or in Canada or somewhere far away, but actually in the region. And so here in East Africa, there are countries that have universal jurisdiction, and there are countries that have sophisticated and robust legal systems that may be interested in taking on these cases. And I think it's a really good idea to explore how such cases could potentially be prosecuted in the region.
Could you tell us what some of the obstacles or challenges that some of the countries which exercised universal jurisdiction faced? And what were some of the ways in which they were able to overcome these challenges?
There have been a lot of lessons learned from other countries who have already been engaging in universal jurisdiction investigations and prosecutions in Europe and Canada, in other countries. And I think there are three main obstacles: resources, the prioritization of cases, and also the practicality of actually apprehending a suspect or an alleged perpetrator. But I do think that it's interesting to see how other countries have dealt with them and to learn from that. So, for example, with respect to resources, there will always be resource constraints because these cases require a lot of expertise. They require a team that will have time and will be able to take on an investigation that is quite complicated and transnational. But we've seen in Europe, for example, the collaboration between different war crimes units when they know that they are investigating similar situations. So there is a sharing of information and exchange of strategy or ideas where they're collaborating with each other, which is a way that they're tackling the minimal resources that they may have available. With regards to prioritization, as we know, international crimes are important because they're so serious and so egregious. But every country will also have a number of other domestic priorities, or in terms of just looking at universal jurisdiction itself, there's conflict all around the world. There are so many different situations to investigate. So how do we pick what to focus on and where to expend the resources? And I think what we've seen in countries that have exercised universal jurisdiction, that they're looking at situations where there is a greater link to their territory, and not just by virtue of nationality, but the types of victims, the types of individuals that reside in their territory and that would benefit from this type of process. This includes refugees or people who have recently fled conflict and who have arrived. And so I think that also is a way that war crimes units are thinking about the prioritization of what is relevant to them. And finally, in terms of the practicality of apprehending an individual, because most universal jurisdiction countries require that a perpetrator be in their territory, what we're seeing is the engagement in structural investigations. We see this in Europe with the Syrian cases. They're actually building a structural investigation where they're building out not only an understanding of the crime bases, but also of the contextual elements of an international crime, and preparing themselves so that if and when they do identify that there is a perpetrator on their territory, a lot of that groundwork is already accomplished. So this is how we've seen other countries deal with this, and we can learn from those lessons.